Friends, if you are watching this video first time, then please subscribe to this YouTube channel, press the bell icon notification button and like this video so that we can update you from time to time. Friends, there is one reportable judgment passed by the Honorable Supreme Court of India on 5th of September 2023. There was a judgment which was passed in there was an order which was passed in the writ petition criminal number 429 of 2022, and there is a petitioner and versus the state of the Andhra Pradesh is the respondent there. So this was in this judgment, in this order, we will see some provisions of Juvenile Justice Act 2000, and the facts of this case was that the petitioner was awarded a sentence by a trial court under the provisions of 302 Indian Penal Code, read with 34 Indian Penal Code, that is common intention, and the 302 Indian Penal Code is the punishment for the murder, in which the petitioner was granted a life imprisonment sentence, and which was also confirmed by the Honorable High Court. And when the special petition was filed, and his sentence was confirmed by, and the Honorable Supreme Court has also dismissed the special petition. So when the sentence was confirmed, the order of the finality was order of the sentence for the life imprisonment has attained the finality. Then another writ petition was filed before the Honorable Supreme Court of India, claiming the juvenility, and the court has issued the directions to the additional session judge to conduct an inquiry. Let's see the contents of the order, what exactly has the Honorable Supreme Court has given. Let's see the contents of this order. So let's kindly stay tuned with this channel. So this is a writ petition under Article 32 of the Constitution, in which the petitioner seeks the verification of his claim for juvenility and the constitutional orders as per the provisions of Juvenile Justice and Protection of Children Act 2000. So this act says that the plea can be raised at any stage. So we called for a report for the duly inquiry, having pursued the report of additional session judge confirming the petitioner juvenility at the commission of the offence. So the writ petition was allowed, and the court has directed that petitioner to be released, who has already gone incarceration for the period of 12 years. So here the maximum statutory punishment under the Juvenile Justice Act 2008 was the 3 years of incarceration. So this is the maximum punishment of Juvenile Justice Act. So here court has allowed his writ petition, since the maximum imprisonment is 3 years, and the petitioner has already incarcerated for the period of nearly 12 years. So the court has allowed his writ petition, and little bit facts have also been elaborated in the para number 2, which says the incident occurred on 21st December 2005, and the petitioner was arraigned as an accused in crime number so and so. By this judgment, 2009 additional session judge convicted the petitioner and co-accused person under 302 and 34 of Indian Penal Code. This paragraph says that on 21st December 2005, the petitioner was made as an accused by the prosecution, and he has faced the trial, and finally he got convicted by the additional session judge under the provision of 302 and section 34 of the. Then the petitioner has appealed against his conviction and sentenced to the Honorable High Court of Andhra Pradesh. By the judgment, by the Honorable High Court has passed a judgment on 10th of April 2014, which dismissed their appeal and uphold the conviction. It means the petitioner did not get relief when he filed a criminal appeal, and then he also filed a special petition against the concurrent findings of the Session Judge and High Court. And this court, by its order dated on 12th of July 2022, dismissed the special petition. So it means even for the petitioner could not get any relief either from the Session Court, from the High Court, as well as from the Supreme Court. So his order of the sentence has achieved the finality to the conviction and the sentence. So then, after 2 months after the dismissal of the SLP, the petitioner filed a present writ petition, praying that the writ of mandamus may be issued to the state to verify the claim of juvenility and to pass the necessary consequential orders. And the court has, in the paragraph number 4, says that the question of juvenility can be raised before any court at any stage as prescribed under Section 7A(1) of the Juvenile Justice Act. Let's see Section 7A, what does Section 7A(1) speaks. Section 7A(1) speaks when the procedure to be followed by a magistrate not empowered under this act. So, and this is a new provision which have been, so it's well settled that the question of juvenility can be raised before any court at any stage as prescribed under Section A(1) of the Justice Juvenile Act, as confirmed by the judicial precedents. So this is what the judicial precedents have mentioned. It's the Hari Ram versus State of Andhra Pradesh and another 2009, which in this judgment it has been held that the claim of juvenility can be raised at any stage before any court at any stage. So here the state filed an affidavit through the inspector of the police. When the court after issued the notice, then state filed an affidavit and through the inspector of the police, and it has, in the affidavit, it has revealed, it has deposed that the petitioner studied at so and so school and has studied from 1st to 3rd standard from 1994 to 1997, and his date of birth was recorded is 2nd of May 1989. And since juvenility was based on the petitioner's school documents, the court considered it appropriate to direct the additional session judge, so and so district, to conduct an inquiry with regards to the plea of the juvenility by the petitioner. And the session judge was directed to conduct an inquiry and to submit the reports after recording necessary evidences by summoning the concerned officials for production of the school records. So, laws clearly says that the claim of juvenility can be raised at any time before any court, 7A(1). So, when the court has issued a notice, so on the basis of the notice, the state has filed an affidavit through their authority, through their inspector of the police, and on the basis of this, the court issued the directions to the additional session judge to conduct an inquiry. And the High Court of Andhra Pradesh has also forwarded a report to additional session judge on the issue of the juvenility of the petitioner, and in this report dated 13th of May 2023, the additional session judge has categorically come into conclusion the date of birth of the petitioner is 2nd of May 1989. So, which is based on detailed examination of documents, exhibits C1 to C7, and oral evidence of witness CW1 and CW2. So we have no hesitation to accepting the same. So the learned additional session judge has conducted an inquiry, and there was a documentary evidences are there, and these documentary evidences were also marked in the form of exhibits, and as well as some witnesses were also their deposition was also taken into record, which was recorded as CW1 and CW2. So finally, the court has got into conclusion they have no hesitation to accept the same. So the date of birth of the petitioner is 2nd of May 1989. So he was 16 years 7 months old at the date of the crime. So petitioner was a juvenile in conflict with the law of the date of the commission of the offence. The court has came into conclusion, since the petitioner was juvenile and his date of birth was 16 of years and 7 months. So he has already gone. The maximum imprisonment is Section 15(1)(g) of the Juvenile Justice Act. Read with Section 16 is the maximum period of which the petitioner could have in custody is 3 years. What does this Section 15(g) says? Let's see the section. The Section 15(1)(g) says to make an order directing the juvenile to be special in case of juvenile is over 17 years but less than 18 years of age for a period of not less than 2 years, or in case of juvenile for the period until the ceases to be juvenile. So this is the G portion. And the part 1 says when the board is satisfied the inquiry that a juvenile has committed an offence notwithstanding anything contrary contained in any of the law for time codes. So G portion says that in case if he is more than 17 years of age, then the period of not less than 2 years is to be sent. His juvenile is to be sent to the to a special home. So this is what G's portion says, provided under section 16 also says that order that may not be passed against the juvenile. So on co-joint reading of these both the provisions, the court has conclusion the maximum imprisonment is 3 years, and he has already gone more than 12 years of the imprisonment. So the court finally accepted the report of additional session judge and held that petitioner is can no longer be incarcerated. So he's been directed to released forthwith if he's not required to be detained in any other case. So there shall be no order of this cause. So this order came on 5th of September 2023. Hope you have liked this video. If you have liked this video, please subscribe to this YouTube channel, press the bell icon notification button, and like this video so that we can update you from time to time. Thank you.